Hello everyone, good evening. Welcome to the session. I hope all of you are doing well. Let's wait for about 2 or 3 minutes. Let's wait for everyone to join in and then we start. All right? Let's wait for 2 3 minutes. Let's wait for about 2 more minutes. Come on, let's wait for another 2 more minutes. Let everyone join in. Let's wait for about 2 more minutes. Let everyone join in. Come on everyone, quickly join in. Come on everyone. Just a minute more and then we start off. Okay, let's start off. Hello and welcome to Unacademy, India's largest online learning platform that gives you a world of courses, resources, content, live and recorded sessions to help you in your preparation for the CA Foundation and Intermediate examinations. Also, welcome to Crack CA Exams with us, which is a vertical and channel of Unacademy that caters to the students of CA Foundation and Intermediate in their journey and pursuit of preparation for the CA Foundation and Intermediate examinations by providing top educators, quality content, and overall a great learning experience. So come, let's crack CA Exams with Unacademy, India's largest online learning platform. Before we proceed, a brief introduction about the educator today. Hello, I'm Prathik Gupta. I am a Bachelor of Commerce from Christ College, Bangalore University. I am an associate member of the Institute of Chartered Accountants of India, an associate member of the Institute of Cost Accountants of India, an associate member of the Institute of Company Secretaries of India, and also a law graduate from Karnataka State Law University. I am currently a practicing chartered accountant and also a visiting faculty for CA subjects and an educator for CA students, both offline and online. Prior to starting on my own, I worked with S.R. Bartley Boy and Associates, that is the Indian member firm of Ernst & Young Global in the Audit and Assurance Department. Post that, I went on to work with Ernst & Young India in the Mergers and Acquisitions Department, and then I went on to work with the Manipal Group in Bangalore as the corporate controller of their Indian entity as well as the German subsidiary located in Frankfurt, Germany. And it was only after I got back from Frankfurt, Germany that I decided to start something on my own. And that also gave me an opportunity to become an educator, which in turn has given me this opportunity to take this session for you young, fine and bright CA aspirants. Thank you so much for giving me this opportunity, and I hope you find this session useful. Anytime during the session, in case you have any questions, queries, observations or discussions to be made, please do not hesitate to drop in a line and I will take up the matter for discussion and or problem solving as the case may be as soon as possible. I would also like to draw your attention to my name, or rather the spelling of my name. It is Prathik, it's Prathik with an H. Okay, it's Prathik, Now I'm insisting on stressing on the spelling of my name because a lot of people misspell my name, due to which they are unable to find my many sessions on the YouTube channel of Unacademy, as well as the special classes on the Unacademy Learning app. So with my name, that is Prathik Gupta, Prathik, you can look me up on the YouTube channel of Unacademy, as well as the special classes on the Unacademy Learning app, and make use of all those sessions for your preparation of the CA Foundation and the Intermediate examinations. Now, like I told you, Unacademy caters to you in your preparation for the CA Foundation and Intermediate examination through 3 platforms. Those 3 platforms are YouTube, Special Class and the Plus platform. YouTube and Special Classes are absolutely free of cost, but they provide you enormous amount of value to help you in your preparation for the CA Foundation and Intermediate examination. YouTube sessions are just what you're watching right now, which are available on YouTube. You need to go there, type in Prathik Gupta, and you can access all my sessions that I've taken on the YouTube channel that will help you in your preparation. Special classes are also absolutely free of cost, and they are available on an app known as the Unacademy Learning app in the form of special classes. They provide you enormous amount of resources to help you in your preparation for the CA Foundation and Intermediate examinations. Alright, and then we come to the Plus platform. The Plus platform of Unacademy is the premium platform of Unacademy. That is a payment-based subscription model which has various subscription packages for the various examinations. Now, more about those packages and the subscriptions I will tell you later on in the slides. In this slide, I will tell you why I recommend and encourage you to become part of the Plus platform of Unacademy as soon as possible. The first reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the daily live classes where you get to chat with your educator, engage in discussions, ask your doubts and answer polls, all this while the class is going on. Yes, you heard it right, all this while the class is going on. You do not need to wait for the end of the class, you do not need to wait for a couple of hours after the class, you do not need to wait for a couple of days after the class or the weekend after the class, and neither do you need to wait to fix up an appointment with your educator to ask your queries and have discussions with him. You can do so on a real-time basis as and when the class is going on. It is as simple as you putting your hand up in a live classroom, and your educator will be happy to take up the matter for discussion purposes and for problem solving purposes as well. The second reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the live tests and quizzes it conducts on a regular and periodic basis to help you evaluate your preparation and also get detailed analysis of your performance. Now you might wonder, why is this evaluation of your preparation and detailed analysis of your performance important? So let me tell you that whenever you're preparing for a professional examination, It is important for you to take a stock of your preparation from time to time to know where you stand in terms of your preparation, as to which areas you're well prepared, which areas you require more preparation, and which areas you might require external help. So basically, the Plus platform of Unacademy helps to break down your preparation into three areas, that is your strong areas, your not so strong areas, and your weak areas, so that whatever limited preparation time you have, you can use that time on those three areas accordingly. In the sense, more time on your weak areas, a little lesser time on your not so strong areas, and less time on your strong areas, until a point is reached where your weak areas and your not so strong areas eventually become your strong areas. So basically, the Plus platform of Unacademy ensures minimum wastage of your precious time and maximum utilization of your limited preparation time. The third reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the structured courses it provides. As all our courses are structured in line with your exam syllabus to help you best prepare for it, which simply means all the Plus courses on the Plus platform of Unacademy are prepared keeping in mind your exam syllabus, so that once you complete a Plus course on the Plus platform of Unacademy, you can rest assured that you have completed the syllabus of your examination without missing out on any important or major point. And lastly and most importantly, the reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the unlimited access it provides, where one subscription gets you access to all our live and recorded courses to watch from the comfort of any of your devices, which simply means the one subscription to the Plus platform of Unacademy gets you access to all the live and recorded courses on the Unacademy platform, which means your live and recorded Plus courses, your live and recorded special classes. It's all available to you, and you can view them from the comfort of any of your devices, which means you can view them on your mobile phone, laptop, tablet, or desktop without any restrictions. Okay, also you can watch them 24/7 without any timing restrictions like 10 to 4, 10 to 5, 10 to 6. No, there is no restrictions whatsoever. All those live and recorded sessions are available 24/7, and you can view them whenever you want by just simply pulling out your mobile phone, logging into the Unacademy Learning app, and start preparing. Also, these sessions are available to you at any location, whether you're at home, whether you're in office, whether you're in college, or whether you're traveling from home to office college, or from office college to home, or you're waiting for someone for a meeting, or you're in a native place, or you're on a vacation and you want to study. You can pull out your mobile phones, log into the Unacademy Learning app, and start your preparations. All you require is a good internet connection or data plan, which all of us are blessed with today. So keeping all these advantages among many other advantages in mind, I strongly recommend and encourage you to become part of the Plus platform of Unacademy in order to, as soon as possible, in order to accelerate and enhance your preparation for the CA Foundation and Intermediate examinations. Please take a minute, go through this. Any questions, please ask me. Any questions, please ask. Please take a minute, go through this. Please take a minute. Any questions, please ask me. Alright, please take about 30 seconds more and then we proceed. Any questions, please ask me. Okay, now in the previous slide you heard me use the term live and recorded special classes, live and recorded plus courses a lot of times. So you might be wondering, where are those live and recorded special classes and plus courses available? They are available on an app known as the Unacademy Learning app. So all of you who have downloaded the Unacademy Learning app and are using it, I thank you very much, and I request your support in the future as well. For those of you who have not yet downloaded the Unacademy Learning app, I request you to go to the Play Store on your mobile phone, log into the download the Unacademy Learning app, install it on your mobile phones, put in your mobile number where you will get an OTP, and using that OTP you can register on the Unacademy Learning app. It is as simple as this, with no lengthy or complicated procedures. So now you might ask me, okay, I have downloaded the Unacademy Learning app, installed it, registered on it using my mobile number and OTP, so what next? So let me tell you that the Unacademy Learning app gives you access to all the live and recorded special classes that Unacademy has to offer to you to help you in your preparation for the CA Foundation and Intermediate examination. And it also gives you access to all the live and recorded plus courses that Unacademy has to offer to you in order to enhance and accelerate your preparation for the CA Foundation and Intermediate examinations. So keeping these points in mind, I request you to download the Unacademy Learning app, install it on your phone, register on it using your mobile number and OTP, and start making use of the enormous amount of resources that it provides to you to help you in your preparation for the CA Foundation and Intermediate examinations. I also request you to spread the word around to help the people around you get to know about the Unacademy Learning app, help them download or install the Unacademy Learning app on their mobiles, also help them to register on it using their mobile numbers and OTP, so that they too can make use of the enormous amount of value and resources that the Unacademy Learning app provides to you to help you in your preparation for the CA Foundation and Intermediate examinations. Alright, please take about 30 seconds, go through this. Any questions, please ask me. Any questions, please ask. Alright, and if you have any questions while doing so, any problem, you can always chat with us and we provide the relevant solution. Please take about 30 more seconds and then we proceed. Any questions, please ask me. Okay, now this is an important slide. Like I told you, the Plus platform of Unacademy is the premium platform of Unacademy. That is a payment-based subscription model and which has various subscription packages for the various examinations. Accordingly, the CA Foundation and Intermediate subscription packages provided by the Plus platform of Unacademy are as follows. The packages provided are for 1 month, 3 months, 6 months, 12 months and 24 months. The 1 month package costs you rupees 3,500. The 3 month package costs you rupees 8,750. The 6 months package costs you rupees 14,000. The 12 months package costs you rupees 17,500, and the 24 months package costs you rupees 21,000. Now please remember, all these are the listed price of the packages. So before you make the payment for the package of your choice, please do not forget to use the code Prathik to get an instant discount of 10% on the above listed price. I repeat, please do not forget to use the code Prathik, P-R-A-T-H-I-K, to get an instant discount of 10% on the above listed price. So the after discount price of the various packages are as follows. The 1 month package will cost you rupees 3,150. The 3 month package will cost you rupees 7,875. The 6 months package will cost you rupees 12,600. The 12 months package will cost you rupees 15,750. And the 24 months package will cost you rupees 18,900. So you see immediately there is a savings of 10% that you get once you use my code Prathik. Now I personally recommend you to start off with the 12 months or 24 months packages because of 2 reasons. Firstly, it is cost effective. If you compare the 1 month package cost with the per month cost of the 12 months and 24 months package, you will see that you're getting great cost savings almost immediately. And secondly, and most importantly, since the CA Foundation and Intermediate courses are provided to you in one package, that is your CA Foundation, that is your 12 months or 24 months package, a 12 or 24 months package will be highly beneficial to you because it covers the duration of both your courses, that is the CA Foundation and the CA Intermediate, which normally take a minimum of about 12 months for you to prepare and clear. So if you're getting a package that is 12 months or 24 months that covers the duration of both your courses, that is CA Foundation and CA Intermediate, at a very cost-effective price, I think that is a very good deal. But having said this, you're free to choose the package of your choice. But before you make the payment, please do not forget to use the code Prathik to get an instant discount of 10% on the above listed price. You can also make use of the no-cost EMI option available for 6 months, 12 months and 24 months subscription packages, just in case you do not wish to make the entire payment at one shot. The payment options available are internet banking, debit card, credit card, and also all the coins that you accumulated by watching the special classes can be redeemed while making the payment for the Plus course. So keeping all these packages, these discounts and offers in mind, and also the advantages, like I told you a couple of slides earlier, in mind, I strongly recommend and encourage you to become part of the Plus platform of Unacademy as soon as possible in order to enhance and accelerate your preparation for the CA Foundation and Intermediate examinations. Please take a minute, go through this. Any questions, please ask me. Any questions, please ask. Take about a minute. Any questions, please ask me. Take about 30 seconds more. Are we done? Any questions? Okay, like I told you, the Unacademy Learning app gives you access to all the live and recorded special classes. Here are the snapshots of few of the many special classes that I have conducted on the Unacademy Learning app and which you can make use of in your preparation for the CA Foundation and Intermediate examinations. There are special classes on Revision Test Paper, Sale of Goods Act, the Indian Contracts Act, the Companies Act, Fundamentals of Accounting, Retirement of Partner, Death of Partner, Admission of Partner, Valuation of Inventories, Revision on Final Accounts of non-manufacturing entities, and revision on sale of goods on approval or return basis, and many more such sessions which you will find useful in your preparation for the CA Foundation and Intermediate examination. So please log on to the Unacademy Learning app, go to my profile, Prathik Gupta, Prathik GUPTA, and you'll see the hundreds of hours of sessions that I've taken on the Unacademy Learning app in the form of special classes which you can make use of. Please take 30 seconds, go through this, and then we proceed. Any questions, please ask me. Excuse me. Excuse me. Okay, And here are the links to few of the many special classes that I have conducted on the Unacademy Learning app. You can either click on these links or copy and paste these links to go to the special class on the Unacademy Learning app and make use of them. There are special classes on the Indian Contracts Act, the Sale of Goods Act, the Indian Partnership Act, the Limited Liability Partnership Act, the Companies Act, Basics of Communication, accounting concepts, revision test papers, and many more other sessions. So like I told you, please log on to the Unacademy Learning app, go to my profile, Prathik Gupta, Prathikgupta, and you'll find the hundreds of hours of sessions that are there. So start making use of them in your preparation for the CA Foundation and Intermediate examinations. Alright, please take 30 seconds, go through this, and then we proceed. Any questions, please ask me. Any questions, please ask. Okay, let's start off with the doctrine of constructive notice. So before we start off, let me just give you a brief introduction about this doctrine. This doctrine is contained or is part of the Companies Act 2013. Okay, now according to this doctrine, anyone dealing with the company, whether it be a vendor, whether a customer, whether a banker, or anyone external person dealing with the company, is assumed to have knowledge of the contents of the Memorandum of Association and Articles of Association, because these two documents are public documents under Section 399 of Companies Act. Okay, because they are public documents, either the company can ask the company for a copy of these, or the company can pay a nominal fee to the ROC and obtain a copy of their Memorandum of Association and the Articles of Association and go through them before they deal with the company. So it will be assumed that they have gone through it, and later on they cannot use an excuse that they have not gone through the Memorandum and Articles of Association. Okay? So on this premise, let's start off. Now, doctrine of constructive notice or knowledge. Okay, so these are a few pointers, a few points. I will explain this and then I'll give you time to read as well. Every outsider dealing with the company is deemed to have notice of the contents of the Memorandum and Articles of Association. These documents on registration with the registrar assume the character of public documents, like I told you, under Section 399 of the Companies Act. This is known as constructive notice of Memorandum and Articles. Okay, so like I explained to you, anyone dealing with the company, any external person dealing with the company is deemed to have knowledge of the Memorandum and Articles of the company, because these are public documents under Section 399. So anyone can obtain a copy of these. Anyone can obtain a copy of these by paying the registrar of companies a nominal fee, or by asking the company itself, and the company is bound to give them a copy. The memorandum and the articles are open and accessible to all. It is the duty of every person dealing with the company to inspect the documents and see what is within the powers of the company to enter into a proposed contract. Okay, so every person who is dealing with the company, it becomes an implied duty for them to check the documents, that is memorandum and articles, before they enter into any contract with the company, to basically find out whether the company is authorized to perform a particular activity or not. Okay, and whether they are authorized to conduct a particular activity or not. In case they are not, then the external people should not be carrying on that business or that activity with the company. So it is the prerogative or the duty of the outsiders, dealing the company to inspect MOA and AOA. Okay, later on they cannot use it as an excuse. Alright, please take about 2 minutes, go through the slide. Any questions, please ask me. Any questions, please ask. Any questions, please ask me. Please take another minute, carefully go through this. I'm giving you ample time so that you understand and you go through it in detail. Okay, let me know once you're done, please. Any questions, please ask me. All right, almost there. Okay, Section 399, 1 of the Companies Act provides the inspection, production and evidence of documents kept by registrar. It provides that the memorandum, MOA and AOA, when registered with the registrar of companies, become public documents and then they can be inspected by anyone on payment of a nominal fee. Like I told you, as per Section 399, they become public documents once the MOA and AOA are registered with the ROC of companies or registrar of companies. So anyone can either inspect them by paying a fee to the ROC or ask the company for a copy of the same, and the company is bound to give them the copy. Alright, so as per Section 399(1) of the Companies Act provides the inspection, production and evidence of documents kept by the registrar. It provides that the memorandum and articles, when registered with the registrar of companies, become public documents and then they can be inspected by anyone on payment of a nominal fee. Therefore, any person who contemplates entering into a contract with the company, contemplates means thinks about, entering into a contract with the company, has the means of ascertaining and is thus presumed to know the powers of the company, has the means of ascertaining, is thus presumed to know the powers of the company and the extent to which they have been delegated to the director. So basically any person who's intending to deal with the company has a means by which it can know the powers of the company and what are the powers that are delegated to the directors. In other words, every person dealing with the company is presumed to have read the documents and understood them in true perspective. This is known as the doctrine of constructive notice. Constructive notice means they already have a pre-notice of the contents of the memorandum and articles of the company. Alright, please take 2 minutes, go through this. Any questions, please ask me. Any questions, please ask. Any questions, please ask me. Take another minute more. Carefully go through this. Alright, let me know once you're done, please. Please take 30 seconds more, go through this. Any questions, please ask. Okay, the next points. The Memorandum of Association and the Articles of Association are two most important documents needed for registration and incorporation of the company. The Memorandum of Association of the company contains the fundamental conditions upon which alone the company has to be incorporated. Okay, so basically the Memorandum of Association contains 6 clauses. Okay, and those are all the important and fundamental clauses based on which the company is incorporated. The 6 clauses are the name clause, the domicile clause, the liability clause, the object clause, the capital clause, and the subscription clause. Out of these, the most important clause is the objective clause, which gives out the main objectives and activities for the purpose of which the company has been incorporated. And the object clause also contains ancillary or incidental objects or activities which are meant important for the attainment of the final goals. Okay, according to section 256 of the Companies Act, defines the memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company laws of this act. Okay, so a memorandum of association means either the memorandum of association what you created at the time of incorporation of the company, or which you amended from time to time and filed with the registrar of companies. So when is the memorandum of association altered? When you want to change the name, when you want to change the location, when you want to change any objects of the company, when you want to change the authorized capital of the company. So whenever any changes are meant to be made, the memorandum of association can be altered, and this altered memorandum of association or the original one which you used at the time of incorporation of your company, both are called as memorandum of associations. All right. According to Palmer, the memorandum of association is a document of great importance in relation to the proposed company. So according to a person named Palmer, the memorandum or the MOA is a great document. It's a document of great importance in relation to the proposed company because it is one of the most important documents. It contains the charter of the company or the boundaries of the company. It contains the object for which the company is formed and therefore identifies the possible scope of its operation, beyond which it cannot go. So basically the memorandum of association contains the main objectives or activities for which the company is incorporated, and the company normally cannot go beyond those activities or objectives. Alright, please take about 2 minutes, go through this. Any questions, please ask me. Any questions, please ask. Take another minute, please. Take another minute, go through this. Any questions, please ask me. Let me know once you're done. Any questions? All right. Thank you. Okay. Any questions? Please ask me. All right. The Articles of Association of Company. Now let's come to the Articles of Association, also known as AOA. The AOA of a company are its bylaws or rules, okay, and regulations that govern the management of its internal affairs and the conduct of its business. So basically, all the internal rules and regulations of the company are contained in the Articles of Association. So the Articles of Association are the bylaws or rules of the company which the company have to follow while the attainment of its ultimate objectives. Okay, so that is the whole purpose of your Articles of Association. And regulations that govern the management of its internal affairs and conduct of its business. According to Section 2.5 of the Companies Act 2013, articles means AOA, means the Articles of Association of a company as originally framed or as altered from time to time in pursuance of any previous company's laws or present act. So, as per Section 2.5 of the Companies Act, your Articles of Association, or the simple term articles, means the Articles of Association that was originally made when you incorporated the company, or which you amended from time to time due to various transactions, and which you filed with the Registrar of Companies. So when do you think your Articles of Association can be amended? When there is an investment, there is an equity investment into your company, a person, external person has invested some money into your company. So in that case, the Articles of Association are amended, or there are certain rules which you need to amend for the better working or functioning of the company. Those are also there. So as per Section 2.5, if your articles means the original articles or the articles which are altered from time to time in pursuance of any previous company's law or present act. Okay? Both Memorandum of Association and Articles of Association are public documents according to Section 610 of the Act. These documents become public documents as soon as they get registered and can be accessible by any members of the public under the provisions of the Act. Like I told you earlier, once your memorandum and articles are registered and your company is incorporated, as per Section 399 of the Companies Act 2013, they become public documents, which means they become open for inspection by the public. Either the company can provide them a copy, or they can obtain a copy from the ROC by giving a nominal fee. Okay? The rule of constructive notice extends not only to memorandum and articles, but also to all such documents as are required to be registered with the Registrar of Companies. So basically, not only the doctrine of constructive notice does not only go for memorandum and articles of association, but it also goes for all the other documents that a company is supposed to file with the Registrar of Companies. There is, however, no constructive notice of documents which are filed with the Registrar of Companies for the sake of records only. Okay, so the main documents to which the doctrine of constructive notice applies to is for the memorandum and articles of the company. Please take 2 minutes, go through this. Any questions, please ask me. Please take 2 minutes. Any questions, please ask. Come on, take about a minute more. Any questions, please ask. Any questions, please ask. Anyone, any questions? Take about 30 seconds more. Any questions? Okay. The effect of the doctrine of constructive notice is harsh to the outsider who does business with the company. An outsider who dealt with the company is deemed to have constructive notice of the contents of the documents of the company, that is your MOA and AOA. An outsider cannot claim relief on the ground that he was unaware of the powers of the company in the case of ultra vires of the company. So the term ultra vires simply means if any activity is carried on by the company which is not mentioned in its memorandum of association, that means it is not allowed to carry on that activity, and then that activity becomes ultra vires of the company. So any person dealing with the company, a customer, a vendor, a banker, is presumed to know the contents of the memorandum and articles of association of the company, and later he cannot claim relief on the ground that he was unaware of the powers. So in a way, the doctrine of constructive notice is a little harsh on the outsiders. Now, why do I say it is a little harsh on the outsiders? Is because they are supposed to know the contents of the MOA and AOA and also understand it, which simply means all that legal language on the MOA and AOA. A common man or a person who is not well versed with these language also is supposed to know and understand, and later on he cannot claim relief that he did not know about it. Okay, so that way it's a little harsh on the outsiders. The doctrine of constructive notice is more or less an unreal doctrine. It does not take notice of the realities of business life. People know a company through its officers and not through its documents. Okay, like when you keep doing business with a company, you kind of build a PR or a relationship with the company. So basically, a company is a non-living thing. So the people build a relationship with the directors and the officers of the company. They maintain a good relationship with them. So this doctrine, to a large extent, is also against that principle of PR and all that. So that way, it's a little harsh. The courts in India do not seem to have taken seriously, though. For example, in Dehradun, Mussoorie Electric Tramway versus Jagman Dardas, the Allahabad High Court allowed an overdraft incurred by the managing agent of the company when, under the articles, the director had no power to delegate their borrowing power. Alright, so even the courts in a lot of cases uphold the doctrine of constructive notice, and they pass the cases accordingly. Alright, please take about 2 minutes, go through this. Any questions, please ask. Any questions, please ask. Take about a minute more. Any questions? Please take a minute more. Any questions? Please ask me. All right. Okay. As criticism of the doctrine of constructive notice, the new theory. Okay, so now because the doctrine of constructive notice, basically the doctrine of constructive notice simply means that any person who is dealing with the company, any external person dealing with the company is presumed to have knowledge of the contents of the MOA and AO of the company, and he is also presumed to have understood the contents. Alright, so this kind of doctrine was kind of harsh, and because of this drawback of the doctrine of constructive notice, there was another doctrine of indoor management that actually came into existence. As criticisms of the doctrine of constructive notice, the new doctrine theory called the doctrine of indoor management has been evolved by the courts. The doctrine of constructive notice seeks to protect the company against the outsider. The other doctrine operates to protect the outsiders against the company. The rule of indoor management is based upon obvious reasons of convenience in business relationships. Firstly, the memorandum and articles of association of a company are public documents, not open to public. Okay, but the details of internal procedures are not open to the public for inspection. Hence, an outsider is presumed to know the constitution of a company, but not what may or may not have taken place within the doors that are closed to them. So, basically, even though the doctrine of constructive notice says that the person is presumed to have the knowledge of the contents of the articles of association and the memorandum of association, but according to the doctrine of indoor management, he is not supposed to know the internal procedures or the policies of the companies. That is something which he doesn't even have access, and he's not supposed to know. So due to a criticism of the doctrine of constructive notice, the doctrine of indoor management came into existence. Alright, please take about 2 minutes, go through this. Okay, go through this. Any questions, please ask me. Take about a minute, go through this. Any questions, please ask. Please take a minute more. Any questions, please ask me. Come on. Any questions, please ask. Also, let me know once you're done. Take about a minute more. Any questions, please ask me. Any questions? Okay. Now the effect of the doctrine of constructive notice or constructive liability. Okay. Now this is also known as constructive notice or liability. The effect of the doctrine of constructive liability is harsh on the other party. It is therefore the duty of every person dealing with the company to inspect the public documents, that is your MOA and AOA, and make sure that his contract is in conformity with their provisions. The Madras High Court discussed the scope and rule of the constructive liability in Kotla, Venkataswamy versus Ramamurthy, The dispute in this case was whether the mortgage bond was validly executed as per the company's articles of association so as to make the company liable. Article 15 of the company's articles of association provided that all deeds, hundis, checks, certificates and other instruments shall be signed by the managing director, the secretary and the working director on behalf of the company and shall be considered valid. In the instant case, the plaintiff accepted a deed of mortgage executed by the secretary and a working director only. The plaintiff accepted a deed of mortgage executed by a secretary and a working director only. The court held that the plaintiff could not claim under this deed. The court further observed that if the plaintiff had consulted the articles, she would have discovered that a deed such as she took required exception by 3 specified officers of the company. Alright, so in this Kotla Venkataswamy versus Ramurthy case, the courts actually ruled in favor of the company, saying that in case the plaintiff had read the articles of association, he would not have accepted a deed which was signed only by the company secretary and the working director, whereas it was required to be signed by the managing director also. So it was the person who dealt with the company's fault. So the court ruled in favor of the company. Alright, and that's why the doctrine of constructive notice is considered to be harsh by many. Please take 2 minutes, go through this. Any questions, please ask. Any questions, please ask. Please take a minute more. Any questions, please ask me. Any questions? All right. Any questions, please ask me. All right. Now, the company, as she would have refrained from accepting a deed inadequately signed. Notwithstanding, therefore, she may have acted in good faith and the money may have been applied to the purposes of the company. The bond is nevertheless invalid. The bond is invalid because the internal procedures of the companies were not followed. One of the effects of the rule of constructive liability is that a person dealing with the company is considered not only to have read these documents but to have understood them according to their proper meaning. He is presumed to have understood not merely the company's powers but also those of its officers. So basically, see, first of all, reading the legal language is a little difficult for a common man who has no knowledge about the legal language, but even understanding it is something that is too demanding, and that is why there was a lot of criticism for the doctrine of constructive notice. All right, please take a minute, go through this. Any questions? Please ask me. Any questions? Please ask. Yeah. Okay. Now, criticism of doctrine of constructive liability, and then which led to the evolution of the doctrine of indoor management. Like I told you, due to the criticism faced by the doctrine of constructive notice, the doctrine of indoor management came into existence. The rule of constructive notice has proved too inconvenient for business transactions, particularly where the directors or the other officers of the company were empowered under the articles to exercise certain powers subject to certain prior approvals or sanctions of the shareholders. Whether those sanctions or approvals were had actually been obtained or not could not be ascertained, because in real situations the investors, vendors, creditors and other outsiders could not dare to ask the directors so many questions about whose sanctions have been obtained as to produce the relevant resolutions. Since there are no means to ascertain whether necessary sanctions and approvals have been obtained before a certain officer exercises his powers, such which as per articles can only be exercised subject to certain approvals, those dealing with the company can assume that if directors or other officers are entering into those transactions, they would have obtained necessary sanctions. This is known as the doctrine of indoor management and was first laid down in the case of Royal British Bank versus Stockport. Okay, so like see, in the Companies Act there are certain powers that are given to the directors, and then there are certain powers that are given to directors which they can exercise only with the approval of the shareholders in the general meeting. So as a general public or an outsider dealing with a company like customer, vendor or banker, you cannot really ask a director whether he has obtained the approval of the shareholders or not, because the directors might get offended and they might take it otherwise and they might lose business. So these were the practical difficulties that the people were facing due to the doctrine of constructive notice, and hence the doctrine of indoor management came into existence. Please take about 2 minutes, go through this. Any questions? Please ask me. Any questions? Please ask. Please go through it. Take 2 minutes. Carefully go through it. Any questions? Please ask me. Take another minute. Any questions, please ask me. Okay, so now let's talk about the doctrine of indoor management as well. Under the Indian law relating to companies, a public company is managed by a board of directors, which is entrusted with the responsibility of managing the company and in the most efficient and transparent manner. Doctrine of indoor management, popularly known as the Turkwan's rule, initially rose from 150 years ago in the context of doctrine of constructive notice. So due to the criticism of the doctrine of constructive notice, there was another doctrine of indoor management that came into existence. The rule of the doctrine of indoor management is opposed to the rule of constructive notice. The latter seeks to protect the company against the outsider, while the former seeks to protect the outsiders against the company. It is in no part of duty of the outsider to see that the company carries out requisite internal proceedings. Okay, it's not possible for any external person who's dealing with the company to find out whether the company follows internal procedures or not. And due to this major drawback of the doctrine of constructive notice, the doctrine of indoor management came into existence. Please take a minute or two, go through the slide, and then we proceed. Any questions, please ask. Any questions, please ask. Please take a minute more. Please take a minute more. Any questions, please ask me. Go through this carefully. Any questions, please ask me. Okay. It is very important to note that the rule of constructive notice can be invoked by the company, and it does not operate against the company. It operates against the person who has failed to inquire but does not operate in its favor. Okay. So the doctrine of constructive notice is in favor of company, whereas the doctrine is in favor of outsiders. Okay, so that is the basic difference between the doctrine of indoor management and the doctrine of constructive notice. Please take a minute, go through this slide. Any questions, please ask me. Alright, please take a minute, go through this. And then let's proceed. Any questions? Please ask me. Okay, let's again talk about the doctrine of indoor management. The doctrine of rule of indoor management has its genesis in English case Royal British Bank versus Turquand. In this case, the directors of the company were authorized by the articles to borrow on bonds such sums of money as should from time to time by a special resolution of the company in a general meeting be authorized to be borrowed. A bond under the seal of the company signed by two directors and the secretary was given by the directors to the plaintiff to secure the drawings of the current account without the authority of any such resolution. Then, Turquand sought to bind the company on the basis of that bond. Thus, the question arose whether the company was liable on that bond. The Court of Exchequer Chamber overruled all objections and held that the bond was binding on the company, as Turquand was entitled to assume that the resolution of the company in the general meeting has been passed. So basically, an outsider really cannot check whether the resolution in the general meeting is passed or not, whether it ought to have been passed, whether it ought not to have been passed. Alright, so basically in this, the Royal British Bank versus Turquand, it was established by the courts that the internal procedures are not something that the outsider should be concerned about. Okay, and he should only be concerned about the objects and the structure of the company. Please take a minute, go through this. Any questions, please ask. Any questions, please ask. Any questions, please ask me. Okay, now we come to the exceptions to the doctrine of indoor management. These are the following exceptions to the doctrine of indoor management in the case where the outsider cannot rely on the doctrine of indoor management. Firstly, if the outsider had knowledge of the irregularity that happened within the company, inside the company, then in that case he cannot take the excuse of doctrine of indoor management. Next thing is negligence on part of the outsider.